Today's presentation is Bad to Worse, Advisor Mistakes in Claims Process. What we will be reviewing today are claims, early warning signs, insurance as your backstop, claims management, advisor actions, resolution, and a little bit of a commercial about Advocates Protective Association and Advocates Broker Services, Inc.'s value. So let's begin. Claims. The thing that's interesting about claims is that it is one of the most difficult and strenuous type of situations that you will, as a professional, will go through. A claim or being sued is a reality of the modern world, but it does unnerve you. We're never really prepared for this kind of emotional challenge that's challenging your professionalism and what you do every day. And it does require you to ask for help. So in being that, you buy insurance to protect yourself and your organization. And it's a requirement also by the provincial regulators, but it is there as a risk management tool for you. So what does a claim or a basis for a legal action really mean? It means that there is a duty of care that's owed by you, and that's being challenged. There is a potential breach of that duty has occurred, and hence they have submitted a suit against you. It could also mean that there was a financial loss that was linked to your actions as an advisor that your client has realized. There's also an expectation that there is a higher standard of care that's owed because you're a professional, because you have designations and so forth, and you are the professional in that relationship. And ultimately, as with every profession, it is the deep pocket situation. They know that you're the professional, that you may be in a better position financially. There may be or may not be insurance. These are all components that are kept in place. And a deep pocket is a reality of professional liability insurance. But we have to also recognize that even though you are realizing a claim or a lawsuit is brought against you or someone has pointed a finger and is making allegations, it does not mean that you made a mistake. It does not mean that you are an unqualified advisor. It does not mean that you're inexperienced. On average, what we found is that over a period of time, the longer you are in a business, that there are a greater chance that you will realize a claim or lawsuit that's brought against you professionally. So what are the causes of errors and omissions insurance? And there are a number of those types of situations that occur. And this is something that happens for many, many professions. And they are common, but the ultimate actions and outcomes are a little different as you go from profession to profession. But in the case of advisors and planners, errors and omissions deal with certain things like clerical errors. Good examples of clerical errors are incorrect address or spelling and so forth in an application. That there is errors that are made in timing of the application. You forget to submit an application at a certain time for whatever reason. Then there's transactional errors where you are trying to buy a certain investment or a unit of trade, so forth, and that is erroneously purchased on behalf of your client, and that causes a potential loss. You may also have a situation where there's a failure to maintain the correct documentation. You haven't maintained that and ultimately causes a problem. And ultimately, there's a failure to confirm the transactions that may cause a claim also. Additional causes of claims are misstatements or misrepresentation. Products of all sorts, mutual fund, life insurance products, etc., are complex documents. They're complex for you, they're complex for clients. Don't take shortcuts. Don't just say, trust me, I'll take care of it. Misstatements and misrepresentations are important components. They are key allegations that can be brought against you. Be clear, be concise, ask that they understand, and it is important that you do that. Nevertheless, those are some allegations that can be brought against you. There's also, as I've been in this type of product line for many years, unrealistic expectations of performance is something that is a common occurrence, that your client may have thought that you've said X and actually it's not correct. or the performance hasn't even come close to what the thoughts were of past performance. Those are key components that come and could cause losses. Lack of understanding of the product in your case, where you're offering a product that you don't understand completely. And that causes a problem because ultimately, if it doesn't perform well, the client is unhappy, they can pinpoint that. And it is a common allegation that you may not understand the product. Failure to follow up or advance for outstanding matters. And that's something that is common for most professionals, if not all, that you need to continue to follow up with your clients. Failure to act in a timely manner. You want to be in a situation where you're constantly, on a regular basis, speaking to your customers, that you are making sure that the documentation that is required is properly delivered to all parties. I've been in situations where breach of confidentiality has happened, and it's simple situations where you're just talking about scenarios and so forth. But I've been in elevators where I've had lawyers standing behind me that are actually talking about situations and naming names and so forth. And I'm listening and gaining all that information. Be careful what you say, where you say it. Everyone is listening. Everyone can be aware of those situations. And there is a confidence level that you have that you must keep under your protection in your office and in your mind. It's important. Third-party discussions and actions. It is something that can happen, could cause a claim against your organization or yourself. You want to make sure that that aspect is covered up too. Unsuitable investments. You've purchased a type of investment that is just too volatile for that client at the age or the type of client and needs that they have. Those are, and this is a situation where it can be detrimental to themselves. And then business activities. You may have other activities. You may have in your office a real estate operation or a development operation or interests. You're providing consulting services. These are not services that can be covered under your errors and omissions policy. You are breaching the trust of your client when you start offering those kinds of services. And you want to make sure that you stay away from that. And your policy will not provide protection for that. So what are the early warning signs? You usually get hints from clients that they're not happy. I'm sure just as professionals of human nature, you recognize when someone's not happy. And it is something that sometimes is very subtle, sometimes it's very abrupt. Everyone has a different style. It's your job as a professional to understand the style of either your client and so forth. But it is something that you have to recognize as you're moving forward with that client and when they may be in a situation where they're unhappy. So they may express dissatisfaction with performance. A simple comment. We talked about buying critical illness insurance in January. What happened? You may not realize that person may have had an event that occurred in that delay. And all of a sudden, you're now exposed. Had you bought the critical illness insurance, it could have prevented a financial situation that your client realized. They actually question your actions. They question why you have made certain transactions and so forth. Again, they're showing subtly their dissatisfaction with what's happening. Or there's a lack of communication. There was a situation where I had a client as an advisor client who had health issues. And that health issue caused him to lose sight of what was happening on a daily basis with his client portfolio. It ultimately caused significant problems because he wasn't attentive to the financial markets and what was transpiring, and caused his clients to realize significant financial losses. And it was across all of his clients. Didn't report it to his sponsor, didn't report it to his clients, obviously, but it did cause significant problems. And then the most easiest, but also the most complex is financial change. I'm trying to get the attention of your client to be honest with you and to tell you what their financial situation is at a given time. It's constantly changing, constantly evolving. The closer you are to the client, the better it is when you recognize those situations. But it's happened to me where I was involved in a project for another client of mine, and my financial advisor would send me an email or contact me, and I wouldn't get back to him. I was so busy that I didn't have time to speak to him. I did eventually speak to him. My financial position did change significantly as a result of what I was working on. And it was for him at that time A little bit of a relief that he recognized what was going on, gave me some advice, but also kept tabs. And it is something that is unbeknownst to him. He wouldn't have known that that kind of change happened in my case. So in recognizing the error, you want to review your file. So something's happened. Your client has said, you know what, I'm not happy. We talked about certain things. These aren't performing well, or I'm not realizing where I need to be, and so forth. So you are pretty clear that this is a situation that is evolving very, very quickly. So take a look at your file. Where have you gone wrong? What's happened? Have you followed the instructions? It could be something that is as innocent as the market has changed, and those investments that may have been the right investments at a certain time or the right products at a certain time aren't today. And that's something that you need to know. What has transpired to make the individual unhappy? Does he have another advisor that is knocking on his door? Does he have another planner that has offered him advice that you don't know and is trying to challenge the situation? And all of these things could have been things that you've already talked to, but because of an elapse in time, you're now in a situation where your client is unhappy because they may feel that they've been wronged. What is their expectation? That is, again, similar to KYC, a constantly evolving situation. And you need to be able to recognize those components. This information is going to be important as the situation becomes a little bit more acute and you need to deal with it. So continuing on, the danger signs, accusations are made or blame is assigned. Your client has finally said, it's your fault. And it is something that it is disconcerting, but it is something that is a reality. You may have clients that are very abrupt, and that's what they say. And you have to deal with that. Client has expressly asked for restitution. They may ask for that. I've been in a situation where an advisor in particular has received a letter from a lawyer on behalf of their customer, or their communication all of a sudden, as an email and so forth, starts to appear or is written in a different fashion, that it becomes more formalized. Similar to that individual that had the health concern, that's what happened to some of those emails. They were starting to get letters from a number of clients that actually read the same. It seemed like they became professional almost overnight. In fact, what was happening was there was a lawyer in the community that was guiding everyone together. A client avoids contact with you. It could be an innocent situation, or they just purposely don't want to talk to you. And or your client has now escalated the contact and has gone over your head. And then you have a situation. So in those kinds of situations, you have an opportunity to do some investigation, but we would normally and customarily recommend to our clients, as I have over decades now, recommended report these kind of situations to your insurance company as soon as you possibly can. You want their advice. You want their help. Don't be afraid to ask for help. It is what you buy insurance for. Why is errors and omissions insurance needed? Firstly, it is a regulatory requirement. Each province has requirements that require that you buy a certain amount of protection. They also have reviewed the types of policies that are available in the marketplace. They are very familiar, the regulators, with what each policy says and what it does. They constantly are interviewing insurance companies and asking them and challenging them to modify and change and improve and so forth. They want to know how far those policies can go. And remember, a regulator is representing their constituency in that province. They're there to protect their citizens in that province, ultimately against you. The next is you have a social and professional responsibility that you protect yourself, and ultimately you're protecting your customers if something was to go wrong. And you're accessing professional and qualified support. Don't put yourself in a situation where you're trying to negotiate. You don't know how far things can go, how bad things can go. You don't know the law as well as lawyers do, insurance companies do, especially as it relates to your profession. And ultimately, insurance is, and I've said this before in past relationships with various clients in all sorts of different type of insurance products, it's a financial backstop. It is like a hedge for you. So your risk management strategy is errors and omissions insurance. for your profession, for yourself. What would it cost to ask for a law firm's retainer? Could it be $5,000? Could it be $10,000? Could it be $25,000? Buying errors and omissions insurance for yourself is far less than that. And you have some of the best proven types of protection available to you. So, insurance is also funding for that legal defense. In many cases, you have to defend yourself. You need to bring in some representation in the suit, the claim or lawsuit, or whatever the situation is. So you want to be able to finance that, and that's what your insurance policy does. Ultimately, if you're found that there was something that was done that was wrong and your client has legitimately had a financial loss as a result of your actions, then there will be an indemnity award or a settlement. And we've also seen this, and it's becoming more prevalent, that regulators get involved in disciplinary review. So when you're involved and being asked to come in and represent yourself with the local regulator, you're in a situation where you don't know what to say and how to say it. They are, as I mentioned earlier, the regulators are representing the constituents in their province or in their country, and they are ultimately trying to protect their citizens from you. So you need to have some representation in that. You need to make sure that you are following the questions that they're asking and are properly answering them, but also not offering more than you should. And that is important. And your counsel through the insurance company, through us, will make sure is there. Ultimately, errors and omissions insurance is legal defense team at a discount. So you are getting the best, the brightest in the marketplace at some of the best prices. Downtown Toronto rates for some experienced lawyers start at $1,250 an hour to $1,500 an hour, while insurance companies, because the volume of what they have and the type of claims they have, are able to negotiate rates that are significantly lower. But also they're able to find the diamonds that are in the marketplace that can offer you just as good service and a more efficient service quicker. So it is important that you have that component. And ultimately, all claims must be defended. That is your obligation. You don't want to be in a situation where you have a claim against you and you're not responding, because ultimately it will go to court. And if you're not responding, you will lose. And then all of a sudden it becomes a very complicated problem and causes significant damage to your reputation, and it could affect you financially. So all regulatory demands must be replied to. As I mentioned earlier, when you're going to sit down with a regulator in a disciplinary situation, or if they're asking for specific questions, you need to respond to them. You need to respond to them in a very timely manner. And you have to recognize that wherever your license is, the various provinces deal with these kinds of demands in a different way. You don't know that normally. It is a situation where one province that is adjacent to another deals with demands in a different way. They may have demands that are specifically related to why you were brought in to that previous province. So they will be asking you very pointed questions. So you want to have representation and all that. And ultimately, E&O insurance is protecting your reputation and your assets. You are buying this protection to protect yourself. And ultimately, that's why it's there. And it's a proven solution for decades. Errors and omissions insurance for many professionals, not only in Canada, all over the world, is a solution that makes sense and has proven results. So the claims management team is a unique group within an insurance company. And they are the individuals that are the other end of the promise. So you buy errors and omissions insurance, you buy insurance generally. And ultimately what that legal contract says is that they promise that if something goes wrong, they'll be there for you. And depending on conditions and so forth, which are applicable to a policy, that ultimately is triggered when there's allegations that are brought against you, or you have a lawsuit that's brought against you, and so forth. So you tap into the insurance company's leadership team, claims leadership team. And who does that include? There's claims adjusters and examiners, there's investigators, there's negotiators and mediators, all of which may be actually lawyers. They also have lawyers internally and externally. And then this is the team. This is the one that is the group that is defending your reputation, your situation, and hopefully being successful either way. Either they pay a settlement or they help you through the whole difficult situation. So what is the life cycle of a claims process? Report your claim situation as soon as you possibly can. The policy says as soon as practicable. So you want to do a quick investigation. You want to either contact SET claims at absinc.ca, or you can call us. Ultimately, what we will ask is if you can gather up some of your information and send us a note, and someone will contact you. So as they go through that investigation process, they will ask you to formally submit a notice of claim. And that is a formality, but it's also beginning steps of getting your representation put in place. And then the claims management team is activated. So they review your files, they collect information. They propose a strategy. There's always going to have to be a strategy depending on the situation, how it's developed, what's going on. They will explain that to you, what they're hoping to be able to accomplish. And then ultimately it is either you settle or you close the claim. And the timeline is the one aspect that is an unknown, because depending on the number of parties in the situation, you are faced with the situation that ultimately you need two lawyers or all of the lawyers to be able to be in contact with each other face to face to make the settlement. So the more parties there are involved, if there are complicated estate issues, if the individual has passed away and now you have children that all have their own representations, you now have a multitude of claims teams that you have to deal with on a situation, it just becomes protracted. So we've seen cases that may take many years to settle out, but others can settle very quickly within a short period of time. So what goes through the diligence process in reviewing and investigating the situation? The insurance company will review your files and records. They'll review your letter of engagement, your KYC, know your client forms. They'll check to see that their client sign-offs have been obtained. They're clear and understandable by someone else's notes. It is quite fascinating how you, after you reflect on your notes, how clear or not clear they are. It is something that is important that you are very concise and thorough when you're making notes. They'll review your emails and other correspondence and the frequency and types of communication. One note that I'd like to add, I've been years ago offered this advice when it comes to correspondence in particular. And the comment that came from a lawyer that I had met with said, if you were to take one of your documents, one of your notes from your file and take it out of context, will it stand on its own? Will a judge sitting in court be able to fully understand what that note meant? So eliminate acronyms, be clear, provide context, allow whoever's reading that document to be clear and understanding of what the situation is. That way, it supports your position. The clearer your communication is, the better it is. So continuing on diligence, did you follow your client instructions on communication? Are they organized? Are they detailed? The defense is built on these files. So part of the whole process will be collection of information and data. You will be interviewed. Your client will be interviewed. Others, as deemed necessary, will be interviewed. As I mentioned earlier, you may have estate issues where others will be involved. Supporting documents will be investigated and reviewed. There are three components to the claims management strategy or the handling strategy, and that is negotiation, mediation, and litigation. So what are your actions, though, as an advisor? Do not accept liability. Don't say it's my fault. Don't offer compensation. That's the insurer's role. Ultimately, your transaction, your errors and omissions insurance that you have paid for, you've handed this situation, this claim situation, this lawsuit situation to your insurers to handle. Allow them that. Ultimately, you don't want to jeopardize their position in negotiating on your behalf. Copies of your insurance policy, as it relates to whatever protection you have, stays in your files. Do not show them to your clients. That's none of their business. That is something that you keep quiet. They don't need to know that there's insurance. It may be obvious, but it is something that you keep at hand. Share your files only with Zurich, the insurance company that you have, or Advocates Broker Services, us as your brokers. Don't interpret your actions in writing to the client. Ultimately, you don't want to create an acceptance of liability. But at the same time, you have to continue communicating with your client. It is one of the most awkward and difficult situations. You are in a situation where your client has said that you haven't performed well on a certain part of their investment strategy or their financial plan or whatever they're commenting on, but you still have a duty to make sure that the rest of their investments, the rest of their financial plan is being taken care of and moved along. That's something that is difficult to do, but it is something that is your obligation as a professional. You need to continue that. Ultimately, communication will begin between your insurance company and your client, and those components will have to be set aside while you continue on. What are your actions? You review your client file in light of these allegations. Be understanding and forthright. Cooperate with regulators. Contact Advocates Protective Associations Claims Management Team, which is your insurance company, ultimately at claims@absinc.ca. Provide them with the details of the situation, seek their advice on how to manage the situation, and above all, follow their advice and directions. So what happens in a resolution? There's a timing issue. It may take a considerable amount of time, or it may be something that will happen very quickly. But it is something that timing is a big part of this whole process. As I mentioned earlier, you may face the realization that ultimately it's two individuals or groups of individuals that need to meet face to face to make sure that this settlement can occur. So by just a simple fact of scheduling may cause delays. But ultimately, it could be a situation where the case is dismissed. A client has realized that this has become a lot more complicated, or in fact, at the end of the day, it's okay. They realize that whatever you've done is okay after they've had the discussions with the insurance company. So the client may withdraw their claim, or at mediation, may determine the claim is without merit. When you have a third party involved in that situation and they say, there's nothing here, you need to move on. If you do go to the next step of discovery, that is a very onerous step. It is a very difficult step for everyone, and it is when you do share all the information in the case, and as it says, everything is discovered and reviewed. At that point, you may find that your client has stepped away from the situation too. So at settlement, awards are agreed to and accepted by the plaintiff, your client. The insurer pays out the award in full, and then they ask for your deductible to be paid to the insurance company. And that's really the three components to a settlement. And what is our value? At ABS, we are constantly making sure that the insurance policy that we have in place for you is comprehensive and is evolving and constantly improving. We built this product and these services to make sure that we're attentive to the needs of advisors in each province and in Canada. We were and are developed these insurance policies by advisors. That was the genesis of the whole program. And we continue to have advisors involved in the leadership of this whole program, which makes us, we feel, a lot more competitive and more aware of the needs of advisors and planners in Canada. We have peer managed and it's operated. It's owned by your community and the advisor community. And over the last 15 years, it has been a proven successful solution. We're national and 100% Canadian. And we're an insurance provider not an insurance company. It makes a significant difference when you're dealing with insurance companies that may come into the market and move out of the market. We've been here, and the association representing this program and sponsoring this program has been in place for many years. Thank you.